So that's what the government has to address. Some 7,000 Canadians have chosen medically assisted death since it was first offered 3 years ago. Now the government faces that challenge: how to open up the option of a medically assisted death to Canadians who may not be facing an imminent death, but at the same time ensuring there are protections for those Canadians who feel they could be pressured into accepting an early death. Well, the government is getting some advice today in a new report from the Institute for Research on Public Policy. The authors say amendments to the existing legislation should open up assisted death to some Canadians with mental disorders. The lead author of the new report is Jocelyn Downie, James S. Palmer Chair in Public Policy and Law at the Schulich School of Law at Dalhousie University in Halifax. She's with me now. Jocelyn Downie, thanks for taking time to speak with me today. Appreciate it.
Oh, it's my pleasure.
This question of medically assisted death for people with mental illnesses, it's maybe the biggest challenge for policymakers. It's being confronted again now as the federal and Quebec governments consider how to respect this Quebec court decision. Why would they be wrong to hold the position that if a person's only underlying medical condition is a mental disorder, they should be denied the option of a medically assisted death?
Because that position would be premised on false beliefs about persons with mental disorders, false and discriminatory. It would be premised on the notion that people with mental disorders lack decision-making capacity, or that we cannot assess their decision-making capacity, or a belief that the suffering that comes from a mental disorder is somehow less excruciating than the suffering that comes from physical disorder. It would be stigmatizing, it would be discriminatory to tell all people with mental disorders that effectively they need to be protected from themselves. To have a blanket prohibition like that would be unjustifiable.
With chronic illnesses and physical disabilities, of course, it's easier for medical professionals to assess a request for medically assisted death. What would have to change to open up the process to people with mental disorders?
Well, the first thing I'd say is that it can be easier to assess the prognosis, the diagnosis, and so on, but not always. The complexity of diagnosis and prognosis, predictability of treatment effectiveness, and so on, doesn't map cleanly onto the distinction between physical and mental disorders. So what we have to recognize is, yes, there's complexity in the context of mental disorders, and we need to respond to that, but let's do that by directly referencing the challenges that you're facing. So in other words, for instance, have a practice standard that says you need to have somebody involved in the assessment of capacity who has expertise relating to that person's condition, for instance, rather than saying anybody with a mental disorder, you can't walk through this door.
So, I mean, you in your recommendations today, which you proposed to the government is to in the assessment process. Tell me more about this distinction between whether the decision to request a medically assisted death should be measured as whether or not it's a good one versus the way the decision was reached by the person making the request.
Right. We don't, with anybody else, decide that you can have access to MAID only if you're making a decision that the provider agrees with and thinks is a good idea. So we definitely don't want the government going down the path of saying, well, for people with mental disorders as their sole underlying medical condition, we're going to assess the quality of their decision. We're going to assess whether it's a good decision or not. What we reasonably could do is say we want to shine a particularly bright light on the process of decision making, because that's where concerns have been raised, and some reasonable concerns have been raised about, for instance, has the person had sufficient time to adapt to a new diagnosis? Have they had sufficient time to see whether a potential treatment will actually be effective? Have people reviewed all of the available social supports and services that are available to this person, so that their decision will be a truly informed and truly voluntary, capable decision. So we look at the process.
Yeah. Okay. And so do we in any way in the current system, do we do that now? I mean, is that the way we evaluate people with an underlying, chronic illness or physical condition? You say that can be traveled to dealing with a person with a mental disorder.
Yeah, I mean, I think you could take the view that this should be handled exactly the same way as we handle all cases of MAID already, which is to follow the path that the trial judge in the Carter decision, the first decision that gave us medical assistance in dying in Canada and the Dusen decision, which has now taken us to this place of by removing reasonably foreseeable, and say, look, this is happening in the context of a physician or nurse practitioner relationship. We trust doctors and nurse practitioners to do these capacity assessments, to have these conversations with patients about all of their options, all of the supports and services, and so on. And we should do the same here. And there isn't a reason for a distinction between physical and mental. Or you could take the view that we need to shine a light on this to make sure that people are paying particular attention. We're alerting them to it's performing an educative function, for instance, and it's also performing a function of allowing the public to feel confidence in the system. Is that we know that these additional, almost, they're not prescriptions, but additional levels of attention are being paid. And that is reassuring to everybody.
Let's follow up on that a bit. You've touched on it a little bit. I want to drill down a bit.
Sure.
What about the argument that allowing people with a mental disorder to choose assisted death is really just an indictment of the lack of proper treatment for mental health? Because that's what we hear, and that we should focus more on resources. You did touch on that.
Right.
We should focus more on that and not give people the state-sanctioned option of ending their lives. Tell me more about that.
So it's the same argument that was made in the context of should we have medical assistance in dying at all, where people said, look, we don't have enough palliative care, so we shouldn't allow MAID until everyone has access to quality palliative care. That argument was run in court in the Carter decision, and it failed because the appropriate response to it, and I think to the same argument being made here, we should only have MAID for mental disorders once everybody has access to mental health services, is you're creating a penalty for an individual for a systemic problem. And what we've argued is to say you need to respond to the individual in front of you and allow them to make the choice in their context with everything that they have for themselves. And you simultaneously need to address the systemic problem of inadequate mental health resources and supports and services. So you do the two together. We've seen that in the context of palliative care. We need to see that in the context of mental disorders as well.
And can this also cover the concerns that vulnerable individuals could be pressured into opting for a medically assisted death? This takes us back, I think, to what you're saying about don't look at the decision, look at the process. So if you can be convinced that along the way this person has come to this decision, despite all kinds of whatever interventions or treatments, they've come to this decision, and we have to accept that.
Absolutely. And we need to recognize that persons with mental disorders do not lose their rights, nor are they all lacking in decision-making capacity. And so how do we respect that at the same time as ensuring that we offer as many alternatives as we can, and that we also work very hard to improve the available alternatives so that the next person who comes along may have more services available to them.
Now, is this the kind of thing you talk in your recommendations as well about the need to develop explicit standards for clinical assessment? Is that something that can be, if this is opened up and the government's facing this tight deadline we've talked about, if this is opened up in the next couple of months, do you believe these recommendations should be applied immediately, or does there need to be some time to develop these explicit standards for clinical assessment of people with mental disorders who may want this option of assisted death?
I think it all can be brought into force in time for March. And I would flag here, everybody's talking about how rapid this is. And that may be because this is when it really hit the news and the consultation went out. But of course, the Dusen decision was back in September. So there's been a lot of time to think about this. And I would also flag that there have been expert reports on this. And there have been provincial territorial expert advisory groups and special joint committee of the House and Senate. So this is not new. And there's also experience in other jurisdictions. So the Netherlands and Belgium both allow this. And so we can look to them and see what criteria do they have, what practice standards do they have, what clinical practice guidelines do they have, and import from there. We don't need to reinvent the wheel. So I think what we can do is put in place whatever changes that the government decides to make to the criminal code, what other changes the provincial governments decide to make to their funding of their health services and so on. Collaboratively, what do they do with suicide prevention strategies and so on? But also we can look to the colleges who regulate physicians and nurse practitioners and say, put in place a standard. We have actually an example of this already in the MAID context, which was there was a window, if you remember a few years back, where people could, it was during an extension of the Carter decision striking down the law. So you could go to court and seek access to MAID. It was this window between a deadline the court gave and a deadline and when the federal legislation came in. And the colleges put in place standards to deal with, because people could have access to MAID. So they put in practice standards. And they had to do that quickly. So it can be done. And I would also note that practice standards are much more easily adjusted than something that's in the criminal code. Colleges are very nimble, much more nimble. And so you can put something in place to deal with the situation in the short term. And then over time, no doubt, all of this will be evolving as guidelines develop and practices develop. We have a Canadian Association of MAID assessors and providers. They put out guidelines to help practitioners know how to deal with tricky cases and obvious cases. So it can be done.
So we've got a legislative deadline approaching, but it's not like in terms of the information that informs how we move forward. We're not starting at zero here.
Absolutely. And the other thing to remember is people with mental disorders as a sole underlying medical condition have access now under the law, right? They're not precluded. So they were in effect kept out, most of them, because of reasonably foreseeable, but it was possible. And people with mental disorders, of course, with, for instance, also cancer, other kinds of conditions, they're already going through the system. The assessors and providers are already dealing with people who bring the complexity of mental disorder into the clinical encounter. And you have to figure out what's the capacity, for instance, in that context. Just because they have reasonably foreseeable was already covered off by, say, their cancer or their ALS. So again, this is not entirely new terrain for clinicians.
All right. Jocelyn Downie, thank you for your perspective tonight. Good to talk to you, and we'll talk again.
Absolutely. Thanks. Bye.